Good day everyone! Another case will be discussed today. Siyempre, torts and damages pa din. Torts and damages cases. If you are new to my channel, please subscribe, share, and like. And don't forget to hit the notification bell so that you will be notified every time I'm going to upload a video. Now, our case will be the first Malayan Leasing and Finance Corporation, the petitioner, versus the Honorable Court of Appeal, Crisostomo BV2 and the Estate of Vicente Trinidad, represented by Widow Gloria D. Trinidad, the respondent. Okay, let's start. The facts of this case is that while Bitug's car was at fault in full stop at the intersection of New York Street and Epifanio de los Santos Avenue, Cubao in Quezon City, were going north, and then there's a car behind his car, and an Isuzu truck bumped the said car, yung Ford na nasa likod ni Vitug, and then it rolled it was thrown uh, on the roof of the car of Pitog and then thrown up. And then the truck bumped the car of Pitog, which um, bumped the car on the rear side, causing the gas tank to explode and setting the car ablaze. Okay, nasunog yung car ni V2. Then may kasama siyang dalawa inside. Swerte lang talaga ni V2 because he was taken off. It was fortunate that he was extricated from the car by by the bystander. May mga tambay doon bago sumabog yung kotse niya. However, yung kasama niyang dalawa inside the car died. And then, nagkaroon siya ng malay, nasa ospital na siya. But unfortunately, his belongings, yung kanyang mamahaling shoes, yung kanyang kwintas, yung kanyang shades were lost already. Wala na. And because of his injury, yung may injury siya, his physician advised him to undergo further treatment, pero it should be done sa US, which ginawa niya naman. And then nung gumaling niya siya, when she got home and get well, of course, dinimanda niya ngayon si First Malayan Leasing and Finance Corporation. Kasi siya yung nakapangalan dun sa registration ng nasabing truck or the truck. But sabi ni First Leasing, leasing company, bakit ako idedemanda mo? And I sold it already to Vicente Trinidad and Gloria D. Trinidad, which the couple admitted naman talaga na during that time of lifetime of Vicente, inano niya, he's the one talaga na nagmamanage nung truck. But syempre, patay na rin si Vicente and si Gloria na lang. Pero they admitted that it was sold to them by the First Malayan Leasing and Finance Corporation, yung truck. And then, at the time of the accident, the Isuzu cargo truck was registered under the name of the First Corporation. And then the lower court granted the first Malayan Leasing Finance Corporation and leave the file to the third party complaint against Trinidad and admitted the third party's complaint filed therewith. So it was brought to the Court of Appeal, and then the Court of Appeal dito rendered a decision making the making that the appeal of judgment ordering the third party dependent appellee, yung estate ni ni Vicente Trinidad to indemnify the petitioner. So yung first Malayan Leasing Finance Corporation, for whatever the amount the that the company must to pay bitug under the judgment and all other respect, and the trial court decision was affirmed. So yung CA nag-affirm din dun sa decision ni sino to? Ni lower court. So ang issue dito sa case na to is that tama ba whether or not the First Malayan Leasing Finance Corporation is liable for the damage despite that it is not being the actual owner of the truck, the Isuzu truck. Hindi na talaga sila yung may-ari kasi admitted naman ni Vicente na binili niya na talaga sa leasing, but yung name was under the said corporation. So the Supreme Court held that in the the Supreme Court held that yes, the FMLFC or the corporation is still liable doon sa nangyaring accident. So the petitioner for review is denied for lack of merit. Ibig sabihin talaga ano pa rin yung petitioner na corporation is still liable for what had happened to VTUG. Kasi siya ang nakaregister eh. So sabi ng court, the registered owner or the operator of record, kung sino yung um, nandun sa rehistro, will be the one liable for the damage caused by the vehicle regardless of any alleged sales or list bidder o kahit thereon. Kahit halimbawa, nabenta niya na yun kay Vicente or kung kanino man or nagkaroon sila ng agreement, may deed of sale, still, the one in the registration will be liable the for the said accident. Okay. The doctrine of this case is that regardless of whoever the actual owner of the motor vehicle might be, the registered owner is the operator of the same with respect to the public and the third person, and as such, directly and primarily responsible for the consequences of its operation. In contemplation of the law, the owner operator of record, so naka-italics yung record natin kasi he is the employer or is the employer of the driver, the actual operator, and the employer being considered merely as an agent. So, ang liable pa rin is the First Malayan Leasing Corporation because the vehicle is named after the said corporation. So, um, in order for a transfer of ownership of a motor vehicle to be valid against the third person, it must be recorded in the land transportation office. So kailangan pagka nakabili, ililipat sa name nung bumili for the liability to be carried on. For although the valid between the parties, the sale cannot affect the third person who rely on the public registration of the motor vehicle as conclusive evidence of ownership. So in law, the FMLFC was the owner and operator of the Isuzu truck, a cargo truck, hence fully responsible or fully liable to the third parties injured by its operation due to the negligence of the driver thereof. So dito, ang liable pa rin is the name at the registration. So that ends our discussion for the case. If this have been very helpful for you, please subscribe, like, and share so that your classmates will also see this a short clip of mine. And if you have any requests for whatever case you want to me to discuss, just leave a comment down below and I'm going to discuss it. Thank you so much.